Good morning, everyone, and welcome to Estate Planning Basics, The Wonder of a Will. I look forward to chatting with you today about all the exciting things around wills, kind of a bit of an overview with a bit of deep dive for questions we often get. My name is Ann Morgan. I'm the Executive Director of the Office of Gift Planning at the University of Missouri, and I'm here with my colleagues who are behind the scenes today helping out. Looking for the questions that you're going to be able to post and other things to help us out, Jen Jennings and Arnaud Boutin. If just a little bit of housekeeping, underneath your screen, you'll see a little place to click where if you have a question, go ahead and type in your question. Arnaud's going to be fielding those, and possibly Jen if we get a lot of questions. And he'll just break in as we get the questions, and there's a good time for stopping. We also will be taking questions at the end. So I really encourage you, whatever questions you have, please post them and we will be more than happy to get to as many as we can. So what are we going to cover today? Why are we even here? Well, we're going to talk about what is an estate. We're going to talk about probate because we had a lot of questions about probate. We're going to talk about wills specifically and trusts and the differences between them, some pros and some cons. And then some things you're going to want to consider as you're looking at your estate planning. So we're going to first hit what counts as an estate. And this may surprise you, but an estate, it's just your stuff. It's what you own when you die, or what you have some kind of ownership interest in as you die. So here's just a list of some of the things that we would consider. Most people, either own or have some kind of interest in. Or that comprise larger parts of their stuff. For example, real estate, cars and equipment, life insurance, bank accounts, investment accounts, intellectual property, things like copyrights, patents, and trademarks, and of course, art, jewelry, clothing, and household goods. Which I think when people think of their stuff, they kind of think of the things they have around them, but there's so many things that go into ownership that when you sit down and actually make a list for it, that you'll be surprised how much you end up actually owing. When we talk about property, especially as it relates to estate matters, we need to take a look at how property is owned, because that determines in a large part of how that would be handled in the estate process. So first of all, we're all familiar with deeds, titles, and certificates. So if you own real estate, you're going to have a deed. If you have vehicles, motorized equipment, some kinds of fine art, you're going to have a title. And then, of course, intellectual property, where you will get your patent rights in certificate form and your copyright in certificate form. So we're familiar with those things. There's something, a thing, a piece of paper, a document that shows you are the owner of this particular property. We also have a very clear system of account holders. We know who the account holder is. Now, in the case of like a multi-layered LLC, it might take you a little bit to drill down into it, but we know who owns the account specifically. And specifically, we're talking about investment accounts, bank accounts, and life insurance. And of course, cryptocurrency would be the same. Of course, that would need to be handled differently because of the key that's used to access cryptocurrency. There are some items that merely by being in possession of them, there's a presumption that they're yours. And this would be what we would call personal effects or tangible personal property. So art and artifacts, jewelry, clothing, household goods, the stuff you really do think about and you're like, oh, here's my stuff that I own. It's, you can put it in a moving box kind of thing. There are exceptions to this though. So just because there's a presumption you own it doesn't mean you necessarily do. If you're leasing a car, and that does not count as ownership. So that would be considered a rental, not actual ownership. And then there's provenance. So provenance is a very fancy term that just means chain of ownership. How did you come to be in possession of that particular item? Was it something that you purchased along the way? Was it given to you along the way? Who owned it before you did? And the concern for that is mostly with valuable works of art and artifacts to make sure that I'm sure you've heard or seen at least some great movies on art thefts, and that's a real concern. And so people pay a lot of attention to that as estates move through the probate process. And of course, the big question here is, what happens when a person dies owning stuff? That's why we're here today. Well, it depends. I know it's a very lawyerly answer, I know, but it depends. Do you own it personally? Do you own it through a trust? Are you a partnership? What's happening with this? So with property that's personally owned, most of this is going to be administered through the probate process, often via a will. Now, only about 40% of people in the United States actually have a will that can be probated when they pass away. And so the other 60%, that happens through some other kind of process, often through the probate court, but it's a different process when you don't have a will. So we're going to talk about that a little bit more later. One important thing to note, though, is that some kinds of property owned this way are going to pass through the beneficiary designation process or right of survivorship, which is very common, especially in real estate. And we'll talk about that a little bit more in depth in a few slides. And then there's, of course, commonly owned property owned by a revocable trust. A revocable trust is a very common estate planning mechanism that does avoid probate. And that's because it's administered according to the terms of the trust. And it does not pass through probate because it's not owned directly by you when you pass away. It's owned by the trust. Now, even though something is in the revocable trust, if there's a beneficiary designation to, say, an investment account that's owned by the trust, it will pass through the beneficiary designation process. The beneficiary designation process, because of the way accounts are held and the way those particular items of property are managed, usually will trump anything that a will or a revocable trust provides for. But we'll get into more of that in detail. So we're going to just hold hands and we're going to do a deep dive into probate. It's not that bad, I promise. It'll be okay. When we look at probate, a lot of times it seems very scary because anything involving lawyers, you just know is going to be unpleasant. But the importance of probate court is that it oversees the administration of a person's estate. So there are eyes on what's going on with a person's property. One of the reasons people aren't real thrilled about the probate process is that it is public and it includes any will that gets filed. So anything going on in a probate process, including financials, including your will, including whatever's happening in court, that is a very public process. Now, some counties and some states will put parameters, a sort of like wall there to protect some of the more sensitive information. For example, the exact property that's owned, the exact accountings that happen. So you have to show that you have a reasonable business interest or some kind of interest in the case in order to get that particular information. But usually that does not include a will. Some states it does include the will. You have to show that you have a beneficial interest in it. But other states, for most states, it is very public. Now, as we mentioned before, there's a different process if there isn't a will. And that's because the court has to determine who the heirs at law are and how the property is to be distributed. Now, this process is called intestate succession. And every state has a plan for you if you don't have a plan for yourself. Usually this involves taking into account whether you were married, whether you were previously married, do you have any children, do you have any minor children, do you have any other relatives, parents, brothers, sisters? If you die without a will and you don't have any of those relations that people can find, your estate escheats to the state. So everything you own becomes property of whatever state you happen to be living in at the time. And that can be a very complicated process, especially if it turns out that if it ends up escheating and then it turns out there is a relative, how do you go about claiming that property? And then every state also has a different way of managing that property. Some states, that property is held in perpetuity and the interest off of that is used for various things for the state. For some places, they just sell it and use the money. So it literally depends on the state you're in, what happens to that. But it's best to have a will because then you decide where that's going, not the state. So the biggest thing that the probate court does is they appoint the estate manager. That's the executor. If you have a will, you can choose who your executor is. If you don't have a will, then the court will appoint one if it's deemed necessary. If you have a large estate or it's intestate succession, somebody can petition to be the executor. But that's one important thing that they do, because what happens is that estate manager, the executor, sometimes called the personal representative, they are the folks who will make sure that everything that's supposed to happen with the estate happens with the estate. Now, expenses related to administering the estate. So basically what you're allowed to take into what you're allowed to be paid for in order to administer the estate. For attorneys who are helping the executors and the executors, they have statutory limits and they have to be approved by the court. So nobody can just step in as the administrator, take all of it as just payment for their immense services to the estate. The court has to approve the fees that they're paid. And of course, the process has deadlines and accountability, which is something that you really want in something in the case of an estate, because you don't want something to drag on for 10 years. And that absolutely can happen if the estate's too complicated or there's arguing among the beneficiaries over unclear provisions. So again, having a good will is as important as having a will at all. And of course, the accountability process, so that there's someone who's held responsible for making sure that all of that stuff happens. So the most key element to this is a will. So let's talk about wills and what they can do for you. So it's important to remember that a will seems like a very complicated document, but it's just something that goes into effect after you pass away, and it's how you want your estate distributed. Dying without a will, again, the process is called intestate succession. Now, in order for a will to be considered valid and able to be submitted for probate, it has to meet certain state law requirements. Now, in Missouri, you have to have a valid testator. We'll talk about that in a minute. 2 witnesses, and then there's something called a self-proving certificate that smart lawyers can add to your regular will that basically means that when you die, we don't have to go back and drag those 2 witnesses into court to attest to your signature. The 2 witnesses portion of this experience is probably the one that is probably where a lot of hiccups happen with wills that aren't allowed into probate. Because sometimes people will think, especially if they're writing their own will, lots of people think, hey, I'm a smart guy. I got advanced degrees in all kinds of STEM things. I can just write my own will. I'll download a form off the internet. And so they do this, and then they go get it notarized, which is nice. Notary's good. That counts as 1 witness. That's 1 witness. And if you don't have that second witness, then it's going to be really hard to be able to get that into probate. Now, I add in the holographic wills are not allowed in Missouri, just because I think it's an interesting piece of history. A holographic will is one that is handwritten and doesn't have witnesses. So basically, it's something where the reason it would be allowed is because it's in your own handwriting. And people, especially before everyone moved to keyboards, handwriting was a very distinctive feature of a person's identity. And so in many states, this would be an acceptable will, even if there weren't those 2 witnesses. However, times have changed, and those holographic wills are no longer allowed in Missouri or many other states. There are a handful of states. And I love it because holographic, it sounds like something out of like Star Trek or something. And it's so not Star Trek. It's very disappointing. Let's talk about the people who are involved, because there are 2 very important people involved in this process of creating and executing a will: the testator and the executor. Wow, my pronunciation. You can tell this is live and unscripted, right? So with the testator, this is the person who signs the will. This is the person the will is theirs. There's really only 2 things that must be met, 2 standards that must be met in order for a testator to be considered a valid testator. They have to be over the age of 18. For most people, that's readily ascertainable when that happens, and be of sound mind. Well, it's a low bar. Don't worry. You just have to know who you are, what you own, and who you're related to. And you don't have to have a lot of specificity about it. You have to know who you are. So you can believe that the world is flat, and you can probably still do a will. If you believe you're Napoleon, probably not. So things to take in mind. You can believe completely crackpot theories, and as long as you know who you are, generally speaking, what you own. You don't have to know it down to like the QSIP number on the stock. And then, of course, who your general relations are. And that just means, do you know that you have kids? Do you know that you have parents and other relatives? So you would know who would be what are considered the natural objects of your bounty, who you would be giving your things to. The executor. So the executor is a person you name in the will, and hopefully more than one. We'll talk about that in a bit. And they have an actual fiduciary duty. So they have a heightened level of duty to properly administer the estate. They are obliged to meet any deadlines. They are both privileged and have the responsibility for selling or distributing property, for accounting for everything, making sure that the debts are all paid. And if there are any testamentary trusts to set up, then they make sure that those get set up. So what can a will do? Well, we talk about what a will is. It's a document that goes into effect after your death to distribute your property. So obviously, it can distribute your property. It can direct how your property can be disposed of or distributed. It can direct that the property be sold and the money distributed, or it can direct that the property be distributed directly. So if you have a house, you can tell your executor, I want that sold, and I want that money to go to split equally between these people who are my relatives. Or you can say, just give them the house and let them deal with it. So it can be either way, or you can leave it up to the discretion of the executor as well. You can name preferred guardians for minor children. You can set up testamentary trusts or other arrangements like life estates. Testamentary trusts are very popular, especially if people have minor children, they have an incapacitated relative that they want to make sure is taken care of after they die. These are actually a fairly common technique to help take care of people that you care about. It names which people and organizations receive property from the estate. One important point here to make is that if you don't have a will or you don't organize your beneficiary designations that way, if you have organizations that you really care about, you would need to add them to your will. There is no organization that can be a natural heir at law. So if, say you have dedicated your life volunteering at the local animal shelter and you really, really want for all of your property to go to this to help, fund the needs of future kitties and puppies. If you don't name that in your will, that can't happen. So that's really important consideration to take into consideration. And then funeral directions. Now, it is not uncommon to include funeral directions in your will. But let's recall that this doesn't go into effect until after you pass away. And it is not unusual for it to take a bit for people to be able to actually locate a person's will. And sometimes that actually happens after the funeral has happened. So if you're a person who has very specific ideas about what you want to see happen at your funeral, for example, I have a friend who's pretty goth, and I have very detailed instructions from them on how to handle their funeral if they predecease me. And it includes somebody standing with an umbrella at the back and looking very mysterious. It's actually pretty funny. Anyway, you're going to want to make sure somebody knows about this before you pass away. And of course, another reminder that it only applies to property actually held by the estate. So property that you owned in person and does not pass through some other mechanism. It's also important to talk about what can't a will do. So these are the other mechanisms. So distributing property not held by the estate. So if it's property that's held in a trust, if it's passing by a beneficiary designation, we're all familiar with our bank accounts that when you sign up to get your account or your retirement fund, there's the line, who do you want this to go to after you pass away? Those are beneficiary designations. And those are forms that are attached to accounts, and you can change those pretty much as often as you'd like. Rights of survivorship. This is often how real estate is owned, especially between life partners. So what it means is that they both own the property equally, and upon one person's death, it automatically belongs to the other person. This is a very common way to hold real estate. And then beneficiary deeds. A beneficiary deed is a deed that is created, that is filed with the land record, so with the regular deeds, that show that after you pass away, this will automatically go to whoever's named in the beneficiary deed. So that real estate would also bypass the probate process. Now, It has no legal effect until after the testator is dead. I keep saying this because sometimes we get a lot of questions about that, but it really does. It also cannot disinherit spouses completely. And in some states, it can't disinherit children completely. So that is something to keep in mind, that there is something called a statutory share in pretty much every state, where if a person passes away and they are currently married to a person, then that person will be able to inherit at least a statutory share, even if you try to intentionally disinherit them. This brings us into the wonderful world of trusts. So what is a trust? We hear that thrown out a lot. And there are actually a lot of different kinds of trusts. But for estate planning purposes, the most important one is called a revocable trust. So trusts in general are documents that create a legal entity. It's similar to a corporation. In the case of some kinds of trusts, like charitable trusts or life insurance trusts, they may even have their own tax ID number. So from the get-go, they are a separate legal entity from you. Now, a revocable trust is an estate planning mechanism that's a kind of trust that can be terminated at will by the person who created it. So that's what's called revocable, because at any moment you can stand up and go, I've had enough of you, and terminate the trust. While the person is alive, it's taxed to the person. It's under their own tax ID number. And then after you pass away, it gets its own tax ID number. So there's a cast of characters attached to this as well. You have the grantor trustor. That's the person who actually creates the trust. You have the trustee who administers the trust. And then you have the beneficiary who has the right to income and or principal assets. So you can see the three hands grasping wrists to show that there's functionally three characters involved in the administration of a trust. Revocable trusts are popular estate planning mechanisms, and they can all be, the grantor, trustee, and beneficiary are all the same person while the grantor is alive and has capacity. It names a successor trustee who's able to step in when you pass away or if you become incapacitated, which a will cannot provide for that. That's something a trust can do that a will cannot do. It does avoid the probate process. It's administered by the trustee. It allows someone to step in as trustee if the grantor is incapacitated, which I already said definitely bears repeating. After the grantor dies, the trust becomes irrevocable, and then the trustee distributes the trust assets. There are pros and cons for a revocable trust. So the pro is that it avoids probate, except for what's called a pour-over will. A pour-over will is just like a short, snazzy way of saying it's a will that's officially filed with the probate court that essentially says, if there's anything I missed putting into my revocable trust, all of that is to be administered as if it were in the trust. And so it's kind of pouring that property back into the trust. The successor trustee can step in while the grantor is still alive. This is a very important thing as we deal with, as you age, your capacity might vary over time. And so having someone who can step in when you can't make decisions for yourself without having any kind of formal probate process or guardianship attached to it can be a real positive for people. It is more private than a will. It can easily set up more trusts or continue even to operate as a trust after the grantor dies indefinitely. And of course, the grantor is still treated tax-wise as the direct owner until death. So all of those are very positive things about a revocable trust. There are some downsides to this. So the downsides are it avoids probate except for a pour-over will. That's the flip side of that positive penny we had. The nice thing about probate is that there are eyes on what's happening, and there's a lot of transparency with everybody involved. With a trust, sometimes it lacks a bit of transparency for the beneficiaries. And if you have a trustee that's perhaps not being as fulfilling their fiduciary duties as one might expect, it can be really hard to hold them accountable for that. So a probate court, you've got somebody holding people accountable immediately all the time. In order for the trust to have power over your property, it has to be titled in the trust. And so accounts, cars, real estate, everything you own has to be titled in the trust for the trust to have power over it. And when I was practicing law, one of the things that was some pretty good money for us when people would pass away is going back and, oh, wow, here's all the property that just never got titled into the trust. So that's something that people would really want to be have a consideration for if they decide to go this route, is just to make sure everything's actually titled the way it needs to be. It can be expensive to set up depending on how complex you want it to be, how complex your assets are, how much trouble you give the attorney. All of those things go into the price point. There are many attorneys now, though, who have a flat fee depending on the kind of estate plan you want to do. So if you want to have just a regular will, if you want to have a revocable trust, other documents that go along with that, a lot of times attorneys will have flat fees as well. And you can just ask your attorney. They should be very upfront with the fees they plan to charge you. And of course, if you want to change something about your will, it has to be formally amended. We're going to step into some corollary documents that go with your estate planning. These are called powers of attorney. So there's a power of attorney for finances and a power of attorney for healthcare. Power of attorney for finances allows someone to step in if you are no longer capable of managing your finances. It does not require a formal guardianship. And this is just, usually people will choose their spouse or their child. If they own separate property than their spouse, of course. If they both own it, then they both have equal say. But the nice thing is that if you don't have this and you do need someone to step in, that would require a guardianship hearing. Now, remember, this is if you can't manage your finances anymore. So there's probably other decisions that need to be made as well. If you're still there and can manage your finances, you can just hire someone like a bookkeeper to help you. But this is if you can no longer manage this on your own and you're not really capable of making decisions for yourself. So power of attorney for finances can be really important, especially as we get older or we start having other health problems or having health problems. Power of attorney for healthcare. I wish I could put bright stars around this without it looking like really tacky. The power of attorney for healthcare is crucial for single adults to have because it allows someone to make healthcare decisions on your behalf. A single adult in most states doesn't have anyone who has the automatic right and responsibility to make those decisions. With married people, your husband, your wife, your spouse, all have that ability to make a medical decision on your behalf if you are unable to. It can be very complicated if there's a single adult and you have two parents and you have a couple of siblings and everyone's disagreeing on what's supposed to happen. And literally nobody has the right to do that. So save your family and the people that you care about some real angst, and just appoint someone as power of attorney for healthcare. This allows the person not only to make healthcare decisions on your behalf, but also gives them access to your medical information. And just as a little sidebar note, there's fillable forms on the MOBAR website. There's free forms available through the Missouri Bar Association website. And you can just download those, fill those out, and then you have them. Congratulations. A living will works in concert with a power of attorney for healthcare, but it's a very different thing. These are advanced directives for providing medical treatments when the end of life is near. So it's care decisions like pain management, nutrition, organ donation, but it's very specific to the end of life care. So nobody has to wonder whether or not you would want someone to pull the plug. So you can put it there exactly what you want. The important thing about all of this is to choose wisely when you're choosing an executor or trustee, including successor trustees. You can pick more than one. You can pick a string of executors. I would say have at least one alternate for everybody that you're picking, because when the circumstance happens that you pass away, the person that you initially chosen may or may not be in a capacity to be able to take that on. Settling an estate can be really complicated. Administering a trust can be complicated. And their life might have become either too complicated or it's gone in a completely different direction and they can't do it, or they just don't want to. It's good to have alternatives when that happens. You're going to want to think about who's most likely to carry out your directions, who's responsible and organized, and who makes good decisions. So take all of that into consideration when you're choosing an executor or a trustee. Minor children. This is always so hard to talk about because, I mean, when you're choosing your guardians, you already know you're choosing second best, because best would be they get to stay with you. But if the worst happens and somebody else has to raise your minor children, then there are some things you need to think about and consider. So there's two parts to watching out for the people who will care for your minor children. They're the people who are going to take physical care of your children, and that's called a guardian. These are the people who make choices for the child's upbringing, like schools, what schools do they go to, what activities are they in band, just kind of like their day-to-day life. And then the people who handle the money are called conservators. And those are the people who take care of any money the minor inherits when there isn't a trustee, of course. They have a fiduciary duty to manage that money for the welfare of that child and make choices regarding spending and saving money on behalf of the child. So they would definitely need to be consulted if the guardian decides that what the child really needs is a really fancy 8-week summer camp out in the Catskills. The conservator would definitely have a say about whether or not that's something that's feasible to pay for out of the property the child will inherit at some point. So with most people, it can be the same person, and you often choose the same person, but it doesn't have to be. And I really encourage people to consider splitting those duties for a couple of reasons. First and foremost, I feel that it protects both the child and the adult that's taking care of them, because it is expensive to raise a child. And sometimes people, and sometimes this isn't true, but sometimes it's true, the people who are best at being a second parent to that child may not be the best at keeping records of how the money gets spent. And then the child turns 18 and was like, wait, I was expecting all this money for college. What happened to it? If the guardian can't account for that, there can be real issues that can end up in court. This also takes some of the pressure off of the guardian in having another person who can help them think through things like how the money gets spent. And the conservator, somebody who's really good with money, may or may not have the people skills and the emotional intelligence to take care of a child. Now, often they will, but again, it bears thinking about having two people serve in those roles rather than just having one person who's taking on all of the responsibility and all of the liability as well. And of course, I would be remiss if I didn't talk about including Mizzou in your plans. Estate giving to Mizzou provides scholarships, capital project funds, professorships, research money. So much happens at Mizzou as a result of the generosity of people who give us some of their resources when they no longer need them. Some positives are that it removes the asset from your estate for estate tax purposes. If you make Mizzou the beneficiary of a retirement account, it avoids that double income taxation that retirement accounts can get when you inherit in an IRA. The gift is used as you direct, whether you want it for endowments or scholarships, capital projects, or all three things. We would use the money exactly as you direct. And it, of course, entitles you to enrollment in the MU Legacy Society and counts toward your inclusion in the Jefferson Club. So you get invited to some pretty cool parties. And we have reached the end of the bulk of the presentation. Jen and Arnaud, do we have any questions?
Hi, Anne. Good morning.
Good morning, Arnaud.
We do have a couple of questions. One that, of course, we hear at these presentations more than once. The question is, when do I need to worry about estate taxes, death taxes?
Oh, yeah, that's a really good question. So there's two kinds of taxes that can be at play when a person passes away, not including income tax, of course, but we're talking about estate taxes. And also sometimes people mean inheritance taxes when they're talking about estate taxes. So when we're talking about estate taxes, we're generally talking about the federal estate tax, which is what gets a lot of press, right? Because once you spend one penny, once you own one penny over $13 million, that has, I think, a 45% taxation rate. So it's pretty astounding. However, a married couple can shield up to 26 million, I think, at this point, from estate taxes, and less than one person in 1,000, fewer than one person in 1,000, actually pays federal estate tax in the United States, because so much money can be shielded from that with proper planning. An inheritance tax is a tax paid by the person who inherits the money. And some states do still have those taxes, although people seem to be turning away from those a little bit. Missouri does not have an inheritance tax, but some other states do. And then they base the tax on how much that person has inherited. So wherever you're living, you may want to check into, ask your attorney, do inheritance taxes and estate taxes apply to my situation?
Thank you. Next question. Can I have a friend serve as my executor, or does it have to be a relative, a family member?
That's a great question. You can have anyone serve as long as they're over the age of 18 and obviously capable of being able to do that. So it does not have to be a relative. It could be anyone you want.
And one that just popped up, I'm not sure you may have addressed this, but has to do with power of attorneys. Can I name a power of attorney in my will?
So in theory, you could put whatever you want in there. However, your will doesn't take place. It doesn't go into effect until after you pass away. And your power of attorney stops being useful the moment you pass away, because you don't have a power of attorney over a person who's passed away. So the power of attorney stops working at that point. So there is a sort of gray area before the executor's powers kick in and the power of attorney powers have gone away. But if you really want that power of attorney to be able to do anything, that needs to be a separate document.
And that was the last of the questions for now.
Well, you all, thank you so much for being a part of our webinar today. Really appreciate your time and attention. Please do not hesitate to call us or email us if you have any other questions or would like any other information. Jen Arnaud and Cheryl Nichols, our fabulous advancement associate, we all stand ready to help you. You can email us at giftplanning@missouri.edu or call 1-800-970-9977 to get a hold of us. Again, thank you so much and have a great day.